Listen-only mode.
Good afternoon, everyone, and welcome to the webinar, the PilieroMazza webinar on avoiding litigation using non-compete agreements to protect your business assets. And thank you very much for joining us. My name is Paul Mengel, and I head up the litigation group here at PilieroMazza, and hopefully you won't need to be contacting me because your agreements will be so tight that you won't be involved in litigation. But in the event you are, we are here to guide you on how to avoid the litigation. And with me is Nichole Atallah, who heads up our labor and employment group, and she's going to start off the presentation.
Good afternoon, everyone. We're going to talk about the topic that no one wants to talk about, which is contracts and contracts with your employees and everything that can possibly go wrong with contracts with your employees. But before we get started, I want to go over just a few housekeeping items with you. We have some internet outages in the area today, so to the extent that the webinar goes down, don't worry. We will get you the slides and a recorded version of the presentation so that you can listen to us at your leisure later. We also understand that you likely will have questions, that many of you do have active non-compete agreements out there, that you may have questions about how you're drafting these, how these things, whether these things are enforceable. We will try to get to your questions today. We're going to really try hard to stay on track and get to a Q&A session at the end of the presentation. But if we don't, we will get back to you after the presentation has ended.
Yes, right. You send in your questions, and we'll be happy to address them thereafter if we can, or of course if the internet goes down or something.
All right, let's dig in. So today, as we said, we're talking about non-compete agreements and other types of restrictive covenants. We're going to talk about why these things can be bad in some situations, why they're a good idea in other situations. We're going to talk about how to properly use restrictive covenants, and we'll go over exactly what is included in this broad definition of restrictive covenant, how to use these things, when not to use them, and what to do when everything goes wrong and you have to enforce one of these things. So what is a restrictive covenant? Okay, well, it's this broad concept that any type of agreement where you're restraining the ability of another entity, a co-owner of a company, or an employee from freely sharing information, competing with your company, getting involved with other customers.
In other words, you're hemming someone in on what normally they would be entitled to do.
Exactly. and we have lots of examples of these, and they can be confidentiality agreements, and a lot of clients are surprised by that. But what are we doing when we're asking an employee or a business partner not to share confidential information of the company? We're restraining their ability to freely share information. The same thing with trade secrets agreements, non-competition agreements, and non-solicitation agreements.
Especially those last two, and as we'll talk about a little bit later with the non-competes and the non-solicitations, it follows that you wouldn't want your confidentiality, your trade secrets, and your secret sauce out there being talked about in the free market. But it's a difficult concept for some folks to understand that you can actually restrain where they are entitled to work because it seems to them to be a God-given right.
Yeah, and although the title of our presentation today really focuses on non-compete agreements, it's hard to talk about any one of these in a vacuum because you don't often see a non-compete agreement alone. You're going to see it with a non-solicitation agreement and a confidentiality agreement, and your confidentiality agreement often includes trade secrets. So we're going to touch a little bit on what you need to make sure that this agreement as a whole is going to be enforceable. The first thing you need to know about restrictive covenants in general is the law doesn't like them. Okay, why don't they like them? Well, as we talked about, you're restraining somebody from doing something that they otherwise would be able to do. And the law views these as restraints on trade. Okay?
And they're downright un-American.
Exactly, that's basically the point, right?
Land of the free, life, liberty, and the pursuit of happiness. I thought I could pursue my happiness any way I wanted to.
Exactly, so states don't like them, and courts don't like them. But they allow them under certain circumstances, in most cases. There are a couple of states out there that don't like them, and especially with respect to employees, which is what we'll really focus on today, is restrictive covenants with respect to your employees.
And one reason, in all seriousness, they are viewed as restraints on trade, and that really matters when you get into the litigation phase. Basically, what that means is that the judges are going to look at these agreements with a fine-tooth comb. They're going to put you under the microscope, and they are going to strictly construe these documents, and they're going to construe them against the employer that is attempting to constrain the employment, if at all possible.
Another important thing to note is that some states have this as common law, meaning there's no book out there that has a law on non-compete. Other states have statutes where they clearly say, look, these are the rules of the road. So it's really important that you understand that these are contractual instruments that are subject to state law, and every state that you're in and operating in can view these things a little bit differently.
And that also goes to which state, we'll talk about later, which states you decide whose law to include in these agreements.
Exactly. One important concept that you need to understand is that restrictive covenants really shouldn't be used as punitive. They should be a way to protect your company, but not necessarily to unfairly hurt another entity. So what are we looking for? They're really meant to protect unfair competition. As we talked about a slide ago, they're restraints on trade, and what the law really wants to protect in these cases is they want to protect and prevent unfair competition. We're not trying to prevent fair competition. We're trying to prevent unfair competition. Things that get in the way of our free market system, right? And how do we do that? Well, courts have basically told us that the first thing we have to keep in mind is these things have to be narrowly tailored. You can't just say, you can't compete with me ever with another competitor. That's not going to pass muster, right?
And moreover, you can't. We see some of these agreements that people have drawn up that say, you will not work in the IT industry for 5 years. And while that might be your desire, the courts are just going to say, no, wait a minute, that's just overly restrictive.
And the reason it's overly restrictive is because courts have said that these things are not here to prevent any competition at all. They're here to prevent unfair competition. So what does a court or state law generally view as unfair? Well, there are things related to what the law deems as quote unquote protectable interests. And these can vary by state. So when we talk about protectable interests, the ones we're talking about today are the most common protectable interests that you'll see out there. They're very commonly accepted, but that doesn't mean this encompasses the entire world of protectable interests. But the first one we see is you have a protectable interest in your confidential information, okay? Your confidential information is important to the company, and we'll talk a little bit later about what it means to have confidential information. The second common protectable interest is trade secrets, right? So, and we'll talk about what a trade secret is later, but it's basically your special sauce, right? And the third one we see a lot in the government contracting realm is goodwill. And what is goodwill? The best way to describe goodwill is it's those relationships that your employees develop with your customers. When they're out there working with your customers, they're also showing your customer what your company can do. And that's a value to you because you've invested a lot in that employee. Finally, you need to understand that the facts matter. A lot of times we get clients that come in and they say, well, I have this great agreement and it's tailored the way it should be tailored and it's perfect. Go out and enforce it. But then they start telling you the story behind it and what the facts of the situation are. The reality is that even if your agreement is rock solid, the facts relating to what's actually going on really are going to matter to a court.
I haven't been in a single one of these cases where the judge has not said or read a single one of these cases where it hasn't turned. Every single court has opinions that dictate that these cases turn on their individual facts, and they're going to look at, you just simply cannot apply a cookie-cutter approach to any of these cases.
The most simple, a very simple example can be, we have some clients who will give every employee that they have the same non-compete agreement. And let's say for a second that you have you're a food service provider, and you give your cafeteria workers at a government installation a non-compete agreement, right? The first thing a court is going to tell or is going to ask me if I walk into court and try to enforce this thing against a common cafeteria worker is, what's your protectable interest? What confidential information, what trade secret, what goodwill are you trying to protect here? Because this person is really just going to another competitor to be a cafeteria worker. You may very well have some protectable interest in goodwill, that this particular cafeteria worker was instrumental in keeping this contract. But you need to be ready to demonstrate that, because the facts are going to matter. And courts are going to be very reluctant to enforce against your average service-type worker that doesn't have any, particular confidential information, trade secret information. Not saying it can't be done, but you better be ready to cross that bridge.
Or the goodwill of someone like, for example, especially like you said in the government contracts realm, where you've cultivated a relationship with a particular officer that over the years that you want to protect after, you've groomed a relationship over many years. And folks, understand we're having some microphone problems. Let me just interject right now. We're trying to address those technically right now. I understand we have one volume that's loud and one volume being me that's not loud. I don't think I've ever been accused of that before, but that's apparently what's happening. So we're working on that right now. So, but it does matter. You might have an employee who, over 20 years, you've invested in, and the goodwill, and has a relationship with the client that decides that the grass is greener on the other side and wants to be lured away. You want to shut them down, if at all possible, from doing that and taking all that goodwill with them.
All right. So what's the purpose behind these things? We've touched a little bit on this already, but the reasons that you might want to consider instituting some sort of restrictive covenant, whether it be a non-compete or a confidentiality agreement, is that there's a lot of uncertainty out there in the world, right? There's a lot of uncertainty with respect to whether employees might just jump ship and go to another employer. And you want to minimize that uncertainty in the world, right? So one way to do that is through contractual agreements. We've already talked a little bit about fair competition, but the purpose of these is to make sure that the playing field is fair, that everybody has a fair shot at your at a contract or at keeping work. You also might want to deter employees from engaging in bad behavior right out of the gate. And if they know that they have a restrictive covenant and they've, quite possibly seen some of these enforced, they might think twice before they go out there and engage in bad behavior to begin with. It also gives you a contractual remedy, right? So if you don't have a contract with an employee, maybe there is a statute or something out there that will help you, but it's going to be a lot more difficult to enforce your rights if you don't have some contract that gives you a right to prevent an employee from doing something. Most importantly, though, I think for a lot of our clients, you have invested a lot of time and energy into developing your business and to developing that confidential information, to developing relationships with employees and customers, and to simply lose all of that investment because someone engages in bad behavior is really, detrimental to the organization.
And two of those points, Nichole, that I'll address. One is the deterrence factor. And that is that you're exactly right. I don't know how many times we've seen a situation where an employer takes action simply because the employer is concerned that if he or she doesn't do so, then every other employee is going to say, hey, look, Joe or Jill went to competitor X, and nothing happened to him or her. And with regard to the confidential information situation, once that toothpaste is out of the tube, you can't put it back in. And we'll talk about a little bit later about in those instances with regard to injunctive relief is how you have to act quickly and on an emergency basis to get that injunctive relief. Otherwise, it's too late.
All right, so let's talk about some things that you need to consider when you're thinking about putting into place a restrictive covenant, or things to think about now, even if you have a restrictive covenant, really, have I done this right? And should I consider different ways to fashion my agreements with employees? And one of the first things you need to think about is what this employee's position and job duties are. And that goes back to our conversation about protectable interests, okay? Does this person actually have access to confidential information? Does this person actually have access to company trade secrets? Most importantly, is this person in a position where they're developing relationships with clients and customers where we can say, look, we have goodwill invested in you and we need to protect that so that you don't run off, go to another employer and take our contract with you, right? But it's really important to evaluate position and duties because one size doesn't fit all. It may not be appropriate to have the same type of agreements with your executive professionals in your organization as with your lower level employees, and you should really give some thought into what types of agreements you want to have with what types of employees.
Right. We often see with these agreements that you know, since they're tailored towards the particular position, as you identify the position by virtue of your position as X, you will be exposed to the following, and you have then a laundry list. Because someone may say, well, that's not a trade secret. Your client list, your contacts, your procedures for doing this or that, those aren't trade secrets. Well, so what you do is you put in your agreement a laundry list of these documents, these processes, these items that are in fact considered by you to be trade secrets. So there can be no doubt down the road, if you're unfortunate enough to be in a litigation, he can't throw or she can't throw his hands up and say, well, I didn't know those are trade secrets, because they've signed a document that says, well, this is what we consider trade secrets. These are proprietary. These are what we're going to protect, and these are what you're not going to disclose.
The other thing you should take into consideration is what form the agreement will take, if any, right? So the first consideration is, do I need one of these things with this particular employee? But then you need to think about, should this be a formal contract? Should this be just a non-disclosure confidentiality agreement? Should this be a formal employment agreement? Or should it be a letter agreement that's more informal but still has the punch of a contractual obligation? What do you have to have? What are essential components of an agreement? The first thing you need to keep in mind, and I'm probably going to say this a gazillion times today, is one size does not fit all.
What, you mean you shouldn't go to the internet and go www.restrictivecovenant.com and...
We see some of those. We generally recommend against it. Because the fact of the matter is that somebody you don't know doesn't know your business, they don't know your employees, they don't know what you need, and they don't know what's going to stick in the jurisdiction that you're in.
And you have the risk of it being either not broad enough or so overly broad that a jurisdiction will simply, like for example, Virginia, for example, say, well, this provision is so broad, I'm going to strike the entire agreement.
Exactly. The other thing you need to have is consideration. And this is one of those legally business terms we learn in first-year contracts in law school that doesn't ever seem to go away. But all this means is that you got to trade something for a value for this agreement. Many jurisdictions have said that employment or continued employment is enough to trade, but there are still jurisdictions out there that require more. And you really have to be careful about where you're enforcing these things. Many of our clients are not engaged in a single jurisdiction, meaning you might be located in Maryland, but you're doing work all over the U.S. That agreement that you crafted in Maryland may not work in West Virginia or California, and you have to be aware of that.
By the same token, given, for example, that Maryland's a blue pencil state and you're doing work in Maryland and Virginia, you may well want to have Maryland law in there because the Maryland judge is much more likely to strike a provision, rewrite it, perhaps for the parties, instead of saying, well, you know what, I don't like this one clause, so I'm tossing the whole thing.
Yeah. So
you need to be very careful, and we'll talk about choice of law and jurisdiction a little later.
And what that magic blue pencil thing means.
Right.
We'll talk about it a little bit, and hopefully that's scintillating enough to keep you on the line. The other thing one of the other things you really have to have is you have to have the substance of the restrictive covenant in there, and we'll talk a little bit about what that means, but you got to have the magic words in there. And then you need to have these general contract clauses, which are really critical but are often overlooked. So we can kind of cruise through consideration because I think I talked a little bit about this already. But again, be aware of state law. Be aware that continued employment could or may not be enough. And be aware that if you don't have something of value that's recognized in the state, it can tank your whole agreement.
Right, and when you're thinking about state law, there's related concepts of not only the law that's going to be applied, but where it will be applied. You may want to have a forum selection clause says that, well, we're going to apply Maryland law, but we agree to the jurisdiction of the Superior Court of the District of Columbia, or you may want to be in the Circuit Court of Fairfax County, Virginia, or you may want to be in the federal courts, assuming you have the jurisdictional amount of $75,000, or if you're looking for some sort of relief that gets you in the federal court. So it matters because some courts are a lot faster than others, and different jurisdictions have different approaches to these. So these are all things that you need to consider based upon the type of work you're performing, where your employees are located, and what sort of activities you're trying to restrain.
Your head doesn't hurt yet. We're going to move on to the substance of the actual clauses, which is a challenge, okay? So what we often see are agreements that make it to the 10-yard line, but they don't quite get there, okay? And the reason is that states have made these quote-unquote magic words or magic phrases so important to the enforceability of these agreements that you really have to focus on what's in here and what am I trying to protect. So again, you have to match the language in that clause up with what that protectable interest is, right? So are you trying to protect that confidential information or that goodwill? But you really have to look at how that language in that clause matches up with that legitimate protectable interest. You've got to have a geographic scope, okay? So that means, what are we trying to do? Are we trying to say it's within 10 miles of our primary business location? That was the traditional way of doing things.
Right, but it has happened, of course, with the urbanization of the United States, and particularly, let's look at, for example, I mean, I'm old enough to remember when 20 miles outside of Richmond or 20 miles outside of D.C. was the country. But nowadays, with a 10-mile restriction on working in any IT industry, and Northern Virginia might encompass half of the companies on the East Coast. So that whereas 50 miles in the Midwest might be perfectly reasonable, or 150 miles. So you really have to look at the geographical area that you're working in the industry, and to try to predict whether or not a court will deem it enforceable based on the facts.
And the way you do that is really by tying that geographic scope back to that legitimate interest, okay? So we have to say, well, I'm a dentist. This is a case we learned in law school. I'm a dentist, so I reasonably don't want my colleague to go out and solicit my customers and, a court, and they said, I think 10 miles is reasonable. That doesn't work very well in the government contracting. So many government contractors have moved to what we call a customer-based geographic restriction. So we don't say, okay, within 100 miles or even across the United States, we say, what are we really trying to protect here? We're really trying to protect an employee from going to work for a competitor and stealing our contracts away from us. Or let's take a business development professional for a minute. You've invested a lot in sending this business development person out there to try to get more clients, to identify more contract opportunities. What I really want to do is prevent that person from going to those prospects, going to work for another company, and then saying, look, I have a relationship with you prospect because of my last employer, and steal that prospect away. So we move to some of these customer-based geographic scopes when appropriate. Many jurisdictions, most jurisdictions have recognized them. Again, jurisdiction-specific, so you have to be careful where you are. The other thing you need to have is a duration, and this is critical. It can't go on forever, right? Your employee that worked for you 10 years ago reasonably isn't going to have a handle on your customer relationships.
As much as you would like to restrain them from ever working in the chosen field after leaving you high and dry for someone else at the altar, that they do. You have to have a reasonable restriction, reasonable duration. Anything beyond the question is what would a court deem reasonable, and therein lies the rub.
And some states, like Florida, for example, they have a statute which says 0 to 2 years. We're going to say that's usually pretty reasonable. 2 to 4 years, we might have some questions, and then after a certain number of years. So there are statutes out there that can give you kind of a general guide, but many states are common law based, and you basically look at other cases that have been out there, and do your best to say what's reasonable in light of this particular set of circumstances.
And the court's going to balance that duration with the scope of the restriction. It's a balancing act with all the factors. It's not just one. But if you do have an overly lengthy duration of 10 years or something like that, it's just not going to fly, irrespective of how reasonable the other provisions are.
You also have to look at the extent of the activity being restricted, and this is where we see a lot of issues in these agreements. So you say, I know Joe worked as an engineer for Department X. Many courts have said that you can't prohibit Joe from just competing in general with the company. You have to reasonably say, well, it's got to be with customers that Joe at least met while he was employed with you, or again, you have to tie it back to that protectable interest, because a court, unless we're talking about an officer of a company, it's generally not going to fly to just have a very broad extent of activity that's being restricted. Let's just talk about confidentiality agreements for a minute. And these have come under fire a lot lately, because our instinct when we're trying to protect our organization is to be overly broad in how we define our company's confidential information. We want everything. We don't want to take any chances, right? Because I can't see into the future. I don't know exactly what this employee is going to get their hands on. So I'm just going to say, blanket, anything that you come into contact with in the company that's not publicly made available is confidential. Well, the law's pushing back a little bit. And they're saying, look, these confidentiality agreements are subject to the same types of restrictions as non-compete agreements. Still have to narrowly tailor them. You still have to think about what's important to your company and what you're truly trying to protect. The National Labor Relations Board has also chimed in on this, and they've said, look, if you give an employee the idea that they can't engage in what the NLRB says is protected concerted activity, essentially, if an employee thinks that they can't talk about the terms and conditions, their wages, those types of employment considerations, then it's too broad and can't prohibit that kind of conduct. So the NLRB has chimed in, courts have chimed in, and they've said, look, we need to start really thinking about what we mean by confidential information. And that means, again, one size doesn't fit all. And what worked for, your friend Joe's company may not work for your company. Really important to carefully analyze that.
Right, and you have to look at the type of business you're in. If you're putting out there for proposals that are out there that are a matter of public record, this is information that's out there, just use common sense. I mean, if I've made this information public, even though I came up with it, it can't possibly be protected. It's already out. You really need to analyze what is proprietary and secret and not publicly available. Not only, and especially with the advent of the internet, there's so much. We'll say, well, this is my client. Nobody knows that, and then you go to your website and you realize, well, you've posted the fact that these are your clients on the internet. So you really have to think about what, in the old days, the pre-internet might not have been publicly available. Now is out there.
The big thing that comes up now is wages, right? And for service providers, this is a big deal because people know your wage rates. They can, find out a lot about your company. So, I had a client come to me and they had a confidentiality agreement that included HR-related matters. And, we took this through the NLRB, and the NLRB said, that's too broad. That can signal to an employee that they can't talk about their wages, they can't talk about the terms and conditions of employment.
And you're basically, their position is you're essentially muzzling your employees from talking about and trying to figure out a way to maybe enhance their compensation, compare, etc.
Exactly. So let's move on to trade secrets agreements. Now, you'll get the slides, so you're going to have the definitions that we've pulled for you. I think trade secrets are tough to conceptually, at least from the legal perspective, to try to, because what you think is a trade secret may not be considered a trade secret under the law. So you really have to look at, what is my secret sauce? What is mine that I've developed? And really, what do I derive some independent economic value from that no other company has? And that's usually what you're selling in some form or another to your clients. But it's important because trade secrets can lead to really contentious types of litigation. Again, how do I know what is a trade secret? again, is it publicly available? Who knows about it? Is it only entities that have some sort of non-disclosure agreement with your company, or is it, posted on the internet somewhere? How many employees know about it? Does every employee you know about it? And if so, is that because that you're pretty small and everybody would know about it, or is this you have 500 employees and everybody knows about it? What have you done to protect it? That question's going to come up. So you need to think about, what have I done? What types of safeguards do I have in my computer systems? What types of agreements do I have employees sign to protect that information? And what kind of value it is.
And what sort of internal security measures have you undertaken? What proactive steps have you taken to protect this data? And in addition to that, of course, you may think it has value, but I mean, just your opinion that, hey, I worked long and hard on this, but it does have some sort of independent value.
Exactly.
And if it's something that you spent decades developing, it doesn't have to be the formula for Coca-Cola, but it does have to be something that you exerted effort and money and expending and to cultivate this information, to develop this information. It has value to you, and that value would be diminished if other people had access to it.
Exactly. All right, now let's get to the topic du jour, which is the non-compete agreements. All right, so all of what we've talked about leading up to this really gives you a foundation to understand the non-compete and non-solicitation piece of this. We talk about non-competes and non-solicitations together because a lot of times they're mishmashed together. A non-compete and a non-solicitation of customers are pretty close to the same thing. Now you'll see a non-solicitation of employees, and that means, don't go out and poach my employees from me, and that's fine. But a lot of times you'll see non-solicitations in the form of, don't solicit my customers, clients, prospective customers. That's essentially very close to what a non-compete is, if not the same thing many times. So we address them together.
Right, they come from the same cloth as opposed to the non-solicitation. And I think the non-solicitation provisions sometimes in these agreements get, as you said, thrown together. Mm-hmm. But going out and working for Company B and then coming back to Company A and saying, hey, it's great over here. You ought to come over here. They're paying me more. They've got this, great snacks in the machine. That's coming back and soliciting, your former colleagues. And we're going to make a distinction between those two.
Courts often address these in a three-part test. And when I say three-part test, this isn't necessarily pulled, verbatim from one particular case. This is kind of one of those standard formulas that we see over and over and over again in different types of scenarios. And one of the first things that a court's going to do is they're going to look at the agreement from the employer's standpoint, right? Is this agreement no more restrictive than what's absolutely necessary to protect that business interest? Again, going to have to identify what that business interest is and why those restrictions were necessary to protect that interest.
Because again, the court's perspective is we don't like these, and we're going to make sure that to the extent we're going to allow a restraint of trade, we're going to allow it to the most narrow extent possible because we believe people should be free to go out there and get gainful employment as long as it doesn't cause harm to their former employer. Exactly.
Then the court turns around and says, okay, if I'm Joe Schmo, the employee, is this agreement unduly harsh? Does it prohibit this employee from essentially engaging in any type of employment?
Isn't that what I want to do?
Well, the law doesn't allow us to. So the law looks at, can this employee be employed? And if they can still be employed in spite of this restriction, then, you're probably going to pass the test. But there are certain situations where, given the employee's particular field and given, some overly broad language perhaps in the actual agreement itself, the court says, look, we're not going to prohibit this guy from getting any income ever.
Right. I mean, I think you have to look at the employment in his chosen field. I mean, you can't, obviously he can be employed if he's an IT person, he can go be employed as a dishwasher. But the court's going to analyze, gain reasonable employment in his chosen field without unfairly competing against his former employer. And in the case if he's going to work for a competitor or with a competitor, the restriction goes to whether or not he could work for the competitor in the same or similar field that he was working for before. He could go to competitor B and work in a completely different job.
And we've had that happen.
In fact, if you have a restriction that says he cannot go work for company B, that's not going to be enforceable because he can go work for your competitor. He just can't go work for your competitor in the same area that he was working for before. For example, he could go work for the competitor as a security guard as opposed to the IT person. So you have to be really careful that you're not overly broad because the court will toss those sorts of restrictions.
The court also looks at whether the agreement comports with the jurisdiction's view of what sound public policy is. And in almost every case that you read or that we read regarding these types of issues, there's going to be some paragraph in there about the public policy of the state of X and what the public policy is in that state, why it's important in that state. So even though public policy is one of those kind of broad, wishy-washy terms, it still pops up and it's still used. And in fact, in California, they've said the public policy of the state is not to enforce these things against employees.
But I think it's safe to say that the general public policy is essentially, as we've said, they're generally not favored, but if you look at the previous two bullet points, essentially it's an incorporation. The court is going to channel the public policy when it does this analysis. And it does this analysis from the employer's standpoint and the employee's standpoint, just as we laid out. These are the considerations that combine to define our public policy, essentially.
So we're going to talk a little bit about that stuff at the end of the contract that no one really wants to pay attention to, but it's one of the first things that we as lawyers look at when we get these things. We look at the stuff we just talked about, which is whether this clause is enforceable on its face. But we also look at what types of general contract clauses do you have in this agreement.
Right, and folks refer to this oftentimes as boilerplate, but and it tends to be, the boilerplate tends to be provisions that people just sort of skim over. I don't know. I mean, I've signed a couple of real estate contracts at closings that had about 800 paragraphs of boilerplate that I didn't read, I hate to confess. But it's really important to pay attention to the boilerplate in these contracts because some of this stuff that doesn't really get the attention it deserves can really turn whether one of these cases is successful or not. So you really have to not ever overlook, no matter who you're working with, oh, don't worry about this boilerplate. There really is no boilerplate in these contracts. You've got to pay attention to every single paragraph.
This is especially important when we're talking about multi-jurisdictional agreements. And what I mean by that is if you have an agreement that you're using in Maryland, Tennessee, Michigan, Montana, Florida, Texas, because that's where you have government contracts at, then you need to be vigilant that those general contract clauses are still applicable in the jurisdictions that you're operating in. And you might say, well, look, I'm a Virginia corporation. Don't we just follow Virginia law? Not so fast. A lot of jurisdictions are going to say, well, the case needs to be brought in the state where the employee works, for example. And you need to be aware that every state has its own little quirks about where it's going to allow the case to be brought, what jurisdiction, if there's a jurisdiction in the agreement, what choice of law is going to be applied. Even if you're in Texas, will they apply Virginia law? Because Virginia law is the choice of law in the agreement.
I think generally speaking, most courts, like, to my experience, and I think that's the case, is most courts will honor, certainly it is the prevalent view, I believe, that most courts will honor choice of law. But these sorts of considerations that Nichole's talking about are really critical because your choice of law determination can decide whether or not, obviously, the agreement's going to be deemed enforceable or not.
Whether you've thought about it in advance is really important because even more important than what a court is necessarily going to do with it, it's what you want because you have a fair amount of discretion in what's going in that agreement. And you can really decide, okay, do I want to be in a jurisdiction that honors what we call blue pencil provisions? And what that is it means that in some jurisdictions, a court can look at a contract clause, for example, a non-compete clause, and they can say, well, you know what? You did leave a couple of words out, or the duration's just a little bit too long. And we're going to, after hearing what the parties have to say, we're going to go in and allow some edits to that provision. Other jurisdictions say, oh boy, no. You guys agreed to something, and if you didn't agree to the right stuff, we're going to nix that whole clause.
That's right, and you have a severability clause in your document that says, well, even if clause 13 is stricken, the rest of the agreement stays in place. If you don't have a severability provision, in some of these jurisdictions, you risk losing the entire agreement. So, for example, Virginia will strike the provision. If the court decides it's too narrow, it's done. It's not going to rewrite it for you. It's not going to try to figure out what was in your mind. Maryland, on the other hand, is a blue pencil. So every state has a different, well, not every state is not different, but there are different ways that the states can approach these things, because some states look at it as, look, we want to give this contract these people bargained for the effect and make it enforceable if we can. We don't just want to toss it out. But so it's important to think about severability provisions. It's also really critical to think about choice of law, which and that goes to your jurisdictional provisions. You can decide if you want which court you'd like to, as I touched on earlier, which court you want to bring it in. Is this a fast court? Is this a slow court? Do my lawyers know all the judges in this court? Do they play golf with them? The venue, but the jurisdiction of the courts, of which state law you want to bring it in, the venue, which particular court do I want to be in? Do I want to be in the Northern Virginia, one of the Northern Virginia courts where my office is located? Do I want to be out in Loudoun County? Do I want to be in Fairfax County? Do I want to be in the city of Alexandria? Do I want to be in Montgomery County? So these are the choices you can make when you're drawing up these agreements.
And this can really impact, your strategy going into litigation. It can impact your cost of litigation because of travel costs and the like. So they're all things you really need to think about. The last thing that we're going to hit on in these general contract clauses is whether you have some sort of equitable relief provision in your agreement. And the reason that's important is because a lot of times what you really want is the employee to stop doing what they're doing, because just by virtue of engaging in the behavior, they're causing you damage. Now, maybe you don't have an exact figure, an exact monetary amount of damages yet, but you need that employee to stop. And that's what equitable relief does. But equitable relief is not automatic, and Paul can speak more to how difficult it is, because we do a lot of this type of work.
Right. Equitable relief comes from equity, which is fairness. And back in the old days, hundreds of years ago, in fact, in Virginia, up until about 20 years ago, there was two sides of the court. There was the law side and there was the equity side. The law decided things that were such as contracts and things like that. The equity was the chancery side of the court, where the chancellor was charged with doing what's fair. It's a completely different issue. It's more Solomon-esque. It goes back to the old days when the water in the river was being diverted, and they would meet in the town square, and the citizens would say, "What are we supposed to do?" And the chancellor would try to say, "Well, I'll tell you what I'm going to do. I'm going to send some this way, and I'm going to send some that way." Equity is fairness. So, in order to get treated fairly, you have to treat fairly. In other words, and there are certain things that you have to do. Your agreement has to not be overly restrictive. If you want injunctive relief, which is emergency relief, that's equitable relief. You have to go into the court and you have to establish to the court, it's the baby is in the burning building argument, that judge, I need relief now. We can't wait 6 months to have a trial on this. That won't help me. If my employee goes to work for company B, he's going to spill the beans. We're going to be unfairly competed against. I'll lose that customer. I'll lose other customers. We have to stop him, and we have to stop him or her now. So you want the court to abandon the normal procedures, the normal timelines. You want to stop what they're doing, essentially, and grant you an injunction. And I don't know how many times we've walked these things into the court in the morning, filed them at 8 o'clock in the morning, gone up to judges' chambers, gotten the other party or the lawyer on the phone, and had a hearing that very day, because if that employee was allowed to take all of our secret sauce and go to work for that other employer, it's too late. 3 weeks from now, it's too late. So injunctive relief, emergency relief, but it's an extraordinary remedy, and so you have to show that if you want the court to move on that basis and you want to get this sort of relief, which is extraordinary, and really doesn't give the other side the chance to present their full case, you have to convince the court that there is no other remedy that would give you the relief you need. You need to make sure that the relief you're asking for, as Nichole touched on earlier, doesn't offend sound public policy, and you usually need to show that there's a substantial likelihood that you're just going to succeed in the long run. You have to convince the court that, Judge, we're going to win this thing later, so give us this relief now because look at these facts. So that's the sort of extraordinary injunctive relief, and you need to put the ability to obtain this relief. You don't necessarily have to put it in your agreement, but it's extremely prudent to say in your agreement the parties recognize that money won't fix this, that we will need injunctive relief, and we agree to subject ourselves to injunctive relief in the event of a violation.
Okay. Well, let's talk a little bit about how we can prevent all of the need for injunctive relief and going to court in the first place, because I think most of our clients would agree that if they can prevent this from happening, it will cost them a lot less money in the long run.
The only one that benefits are the lawyers, and we wouldn't want that happening.
Exactly. So one thing that you can do is make sure that when an employee leaves your employment, for whatever reason, whether it's because you fired them or because they quit or because their mom got sick, whatever it is, whatever reason they give you, doesn't matter. When that employee walks out the door, they should have a copy of any agreement they signed with you that has post-employment restrictions in their hand when they walk out the door. And if they called you to tell you they quit, make sure you send one to their house or via email or whatever the common way to get in touch with them is. If you have the opportunity, you should also make sure that you counsel the employee on their post-employment obligations. And that can be very, very simple. It can be, hey, Joe, here's a copy of your agreement. Guess what? You have some obligations, and you need to remember that this stuff is confidential information. You can't share it with anybody.
The exit interview.
Exactly. It's the exit interview. And you need to make sure that you ask them for your stuff back, right? Say, do you have any email files at home? Do you have any confidential copies of things that you should have back?
And that should be also a provision in your agreement. You should have in that agreement, employee upon departure agrees to return computers, laptops, all property, all documents, destroy any copies in his or her possession, et cetera, et cetera. Because I can't tell you how many times we've had cases where employees have downloaded contracts, downloaded proposals, downloaded confidential information to their, or emailed them to their home laptops. And guess what? It's not that hard to actually get a forensic expert to go in there and find out who did what and go into somebody's laptop and get it, but it costs a fortune.
Exactly. The other thing that you can do, if you know what employer the former employee went to, you can send over a copy of the employment agreement that you had with Joe or whoever it is and say, hey, not sure if you know this, but he or she has post-employment obligations to us for the next 12 or 18 or 24 months. And if you have any questions about it, let us know. We'll talk about some common law, non-contractual remedies that you might have as an employer in this situation in a bit. But essentially, it can set up a very worthwhile claim if that new employer continues to use this employee for bad purposes and they know that they're doing it. It can put you in a position to make a claim against the new employer as well.
Who, after all, is the person that probably has the deep pockets that you're going to need.
Exactly. The other thing you want to do is, if you have the information, take a look at what the employee is doing at this new job. What position is it? What line of business is it? Does it interfere with those protectable interests that we talked about? Because that's one of the first questions a lawyer or a court's going to ask you.
And that's going to be the subject of the first letter that you or your counsel sends to them, saying we have reason to believe A, B, C, D. Here's a copy of the agreement. We believe that it's highly likely that Jolene or Joe Smo is competing against us and has violated this agreement, and we want a response for the next days.
Yeah. Another thing you need to take into consideration is, what's an acceptable outcome for you? Is it truly that I want to enjoin this employee from working for this particular entity? In some situations, that's an uphill battle. Resources are perhaps an issue. And many times it could be a subcontractor or prime contractor issue where an acceptable outcome might be some sort of buyout of the profits related to this employee, that kind of thing. So you need to think about what that acceptable outcome is and decide, do I want to engage in some meaningful negotiations with that employee or that new employer?
Because believe me, negotiating some sort of amicable and agreed resolution is a far cry better than litigating. As much as I like to do this stuff, it is extraordinarily expensive.
Okay. So what can we get? Let's say that we have to go to court. What types of remedies do you have? We have the basic contractual remedies, which is what type of monetary damage did I incur as a result of this bad act, right? That's your most common contractual remedy. Then you've got some common law tort remedies. You know, there might be some, basically he stole my information, right? There could be some, you know, theft conversion type remedies or type claims that you can put out there. There can also be something we referred to early called basically a tortious interference claim, and they call it different things in different jurisdictions, but it's basically like, hey business, you knew that I had a contract with this employee, and you went ahead and by improper means did something bad anyway, and it's cost me money.
Even in some cases, it's so egregious that you can even bring in conspiracy type, business conspiracy type statutes, which often have they're criminal in nature, but they all have similar remedies and often have provisions for double damages or treble damages and attorney's fees provisions, which is really important in these cases. And you want to have that included in your agreement in any event, that if you have to bring litigation to enforce your non-compete, that the prevailing party is going to be awarded the attorney's fees, so that the employee who goes out there says, oh, wait a minute, if I breach this agreement and I have to defend myself, I might have to pay my lawyer and their lawyer. Believe me, that's a big disincentive to cheating on one of these sorts of things.
The other thing that you can look to is that many jurisdictions have trade secrets or intellectual property statutes that could be implicated by a violation by the employee of stealing trade secrets, that kind of thing. And we talked a little bit earlier about the types of injunctive relief that might be available. So what happens when litigation happens? Because that's an important consideration when you're thinking about, how do I negotiate my way out of this? How do I repair the harm? And knowing in full what's before you is going to be important when you get into this.
And we've touched a little bit about on which venue you need to be in. We've talked about the injunctive relief, how that usually it usually takes the form of a temporary restraining order is the first thing you would get if you prevail. You would it would have a short duration, which would be limited until the court could bring the parties in and have a more substantive hearing. Then you would go to the temporary injunction or preliminary injunction, and then maybe a permanent injunction at the end of the day. But litigation would have different phases. You would have the initial phases where you may seek injunctive relief. Then there would be an entire period where there would be a discovery process of exchange of document requests and interrogatories. Depositions would be taken, and then that's of course a very expensive process. In this area, usually you're talking about, because of the influence of the Eastern District of Virginia rocket docket, you're talking about within a year to get to trial in most of at least the metropolitan D.C. area jurisdictions. And so that's basically the time frame. But the discovery process can be really expensive. The motions practice can be very expensive. So you have to know that factors into whether or not you make the choice to litigate these things or resolve them amicably, frankly.
And in many jurisdictions, they have alternative dispute resolution processes. Often there's mandatory mediation in some jurisdictions that you need to take into consideration when you're thinking about the litigation strategy and how you want to maneuver through a litigation process.
Right. You file in federal court, you're probably going to get a federal magistrate for free, an experienced judge, to try to mediate the dispute. And those are processes, I think they resolve, I think 85% of cases are resolved before they go to trial.
These judges have been around for a long time, and they're going to quickly tell you if they think you have a case or what the strengths and weaknesses are at very least. So what happens if you don't enforce, right? I mean, there are reasons not to enforce agreements, most certainly, but you need to know what could happen if you fail to enforce an agreement. So in some cases, if you let it sit for too long, there are all these, legal doctrines out there that says, you know what, you've waited too long. Was this really an emergency if you waited a year and a half to bring any sort of claim against this particular person?
Or even 3 months. It depends.
Yeah.
I mean, if you're going to go into court and say my hair's on fire, you better not do it 3 months after the employee left and has already been working there for a while. I mean, if you're going to pull the trigger on injunctive relief, you need to do it quickly because, of course, you're trying to convince the court this is an emergency. And an emergency is not an emergency. If you've waited, well, I don't know, is he really a competitor or is he really hurting us 6 months down the road? This court's going to say, hey, I mean, if I'm the lawyer on the other side, the first thing I'm going to say is, Judge, if this was such a big deal, they would have been in here 6 months ago. And the court's going to look at me and go, well, Mr. Mengel, how about that?
And it could be that you just found out. I mean, there could be reasons why you waited, but you should keep that in in mind that if you figure something out or you have reason to know something, don't ignore it. The other thing is, if you don't enforce against, Mary or Joe, then you have 6 other employees that might think, well, Mary and Joe told me that the coffee's good over there and they're getting $30K extra a year and things are pretty sweet and I should come over there too.
And the company didn't do anything about it when they left.
So why should I be worried about this, meritless piece of paper that they gave me when I started working for them 5 years ago? So you have to, it's always a balancing act, but you have to be aware of the impact that non-enforcement can have on your entire workforce.
They talk.
Yes, they do.
And they may well be luring somebody to come with them and say, hey, you take the plunge, I'll see how it shakes down. If you make it, I'm coming with you.
It's worth a second or two just to talk about what happens when you're on the other side of the coin. What happens when you hire somebody who has a restrictive covenant and you are hopefully caught unawares of what it is or that they even have one, right? So we mentioned this tortious interference claim earlier, but usually what you're going to get as the employer is a letter from a lawyer or a business that says, hey, you hired my employee, now you know about my agreement, and if you do anything that hurts me, I'm going to bring a claim against you because they see you as the deep pockets, right?
They're putting you on actual notice that there's an agreement out there, so you can't possibly deny it later.
Exactly. So what can we do to avoid that kind of scenario? First of all, we can ask employees when they apply or when they start working for us, do you have a restrictive covenant? Is there anything I need to worry about? And in fact, if you're making them sign an agreement in order to be employed with you, you can have a warranty in that agreement that says, hey, I check the box that I am not subject to any type of restrictive covenant, confidentiality agreement, or let's say they do tell you, at least you know what you're working with.
And don't use the words restrictive covenant.
Yeah, they won't know what that is.
Speak to them in English.
Exactly.
Because did you have any agreements with your former boss that had anything to do with you going to work for somebody else? Because you say restrictive covenant, after you get sued, they're going to say, oh, you mean this? This is a restrictive covenant? I didn't know that.
Exactly. So broad terms, and a lot of times you can put it in an offer letter, you can put it on an application, you can tell them to write in what agreements that they have, and if they do have an agreement, to include a copy. Knowledge is power, and you need to know that what's out there. You can also look at whether the agreement they have is enforceable, right? I mean, it could just be a piece of junk that doesn't work in that jurisdiction, and you just say, I don't have to worry about it. And you need to find out what the other side wants to see if you can resolve the issue. It very well could be that employee is important to you.
Before you shrug it off, I would check with someone.
Exactly.
Not necessarily us, but somebody.
Because the reality is once you get sued, you can't get out until you reach an agreement to get out, and you lose that power. So, just in sum, and I'm sorry we're not going to have a lot of time to answer questions today, but again, we will get back to you. But when you're looking to protect your interests, you really need to identify the issues that could be out there with respect to the agreements that you already have, defending yourself against hiring employees that may be subject to these types of restrictions. Identify the issues. Think about those protectable interests. Think about enforceability. Be careful when you share information because, again, that's going to go back to whether something's confidential, whether something's a trade secret, whether you really have a protectable interest to begin with. And it also goes to, what people should have certain types of information in your organization. Use written agreements when they're appropriate to use them, and they may not be in all situations, but use them when it's appropriate to use them. And, of course, you guys are business owners. You know of the black hole, the trust me approach. You've probably run into it a few times. It's all well and good when you're starting the honeymoon, but a few years down the road, things might not be so pretty.
Right. I mean, let's face it. When you bring in somebody on, you're excited about this person, you're starting a new relationship, they've got an asset they're going to bring to the company, and you're signing these documents that say, listen, you're not going to do A, B, C, and D, and if you do, I'm coming after you, and you're going to pay my attorney's fees, and you're not going to do X, Y, and Z. And that's not the kind of thing you really want to think about when you're taking on somebody new, but believe me, you have to. I mean, that's why they have prenuptial agreements. I mean, you're all in love and everything's wonderful, but down the road, you want to make sure what happens when the relationship goes south. And you don't want to be left holding the bag when this employee takes your trade secrets and goes and competes against you and said, oops, I wish I'd made that agreement tighter, or oops, I wish I hadn't downloaded that one from the internet.
Exactly. Again, I apologize that we're lawyers. We talk much more than we should.
Even when we're not getting paid for it.
And we will send the presentation out via email. You'll also get a recording so you can listen to this as much as you'd like. And please, if you have any questions, contact us. We're happy to help.
Thank you folks very much for your time. We really appreciate it.